Hello everyone. We got disconnected towards the end of the lecture today. So I thought that I'll just make a presentation. I'll just record a video and send it to you. So although we discussed till the fourth issue, I thought that it's better in this video if we start from issue number 1. So in continuation of the Ericsson versus Competition Commission of India's case, the first issue was, is Ericsson an enterprise within the meaning of Section 2H of the Competition Act? Well, if you remember, Ericsson's claim before the High Court was that it was not an enterprise as is understood under Section 2H of the Competition Act. So the High Court is looking into whether Ericsson could be considered to be an enterprise or it could not be considered to be an enterprise. Now, the court considered that yes, Ericsson could potentially be an enterprise for the purpose of competition law because Ericsson has a very large portfolio of patents and is engaged in developing different kind of technologies, and also they acquire a lot of patents. Now, the High Court says that if patents can be held to be goods, Ericsson will definitely come within the definition of enterprise as is understood under Section 2H of the Competition Act. Now, the court held that yes, patents could be considered to be goods, although definitely patents are not tangible property, but even then it can be considered to be goods, and as such, Ericsson can be considered to be an enterprise under Section 2H of the Competition Act. Coming to the second issue is, does the Indian Patent Act act as a special act prevailing over the Competition Act in matters of abuse of patent rights? So Ericsson has again raised this issue that the matter pertaining to this case falls under the Patent Act because it is about licensing of a patent, and if the aggrieved party has a problem with regard to the licensing of the patent, Ericsson submitted that the appropriate forum should be the authority under Indian Patent Act to decide whether patent licensing should be granted or not be granted. They even indicated towards compulsory licensing mechanism. And another important submission that Ericsson made was that the Patent Act is a special legislation and Competition Act is a general legislation, and in case of conflict between special legislation and a special legislation and a general legislation, it is the special legislation that gets predominance over the general legislations. So let us look into what the High Court had to say. So the High Court said that definitely the High Court said that yes, Patent Act is a special act, it's a special legislation. But even competition law or Competition Act is also a special act. So the court basically looked into certain provisions of the Competition Act. First, it looked into Section 60. Now, Section 60 of the Competition Act, if you refer to the Bare Act, it says that the provisions of the Competition Act will have effect notwithstanding anything that is inconsistent with any other laws for the time being in force. So it says that irrespective of the fact that there are certain inconsistency between the competition law and the other legislation, the provisions of the competition law will have effect. So that's Section 60. Now Section 62 of the Competition Act, which says that the Competition Act shall be considered to be in addition to and not in derogation to the provisions of any other law which is existing in the time being. So in the third bullet point, you can see that the High Court has held that the intention behind the Competition Act was never to whittle down the scope of any other law. Hence, they said that Section 60 and Section 62 has to be read together. So Section 60 says Notwithstanding anything, the competition law will prevail, although there is any kind of inconsistency with the other laws. Section 62 says that so competition law will be in addition to and not in derogation of the other laws. So the High Court is saying that both this provision has to be read harmoniously, should be read together and in context of the subject matter of the Competition Act. So it is saying that these two provisions, one is a non-obstante clause, the other one is saying that it is in addition to, not in derogation of the other laws. So they will be read together. So they are not saying that in case of conflict between section 60 and 62, 60 will prevail or 62 will prevail, but they are saying that keeping in mind the context of the competition law, both the provisions will be read together. Now coming to the conflict between competition law and patent act, in the last point you can see that the court is referring to two provisions. One is section 27 of the Competition Act and section 84 of the Patent Act. Section 27 of the Competition Act basically talks about the procedure not the procedures, but the orders by the CCI in case of inquiry of abuse of dominant position or anti-competitive agreement. So the thing is, if there is a decision given under section 27, that is an order after inquiry into anti-competitive agreement or abuse of dominant position, so that is section 27, and section 84 of the Patent Act is basically about compulsory licensing of patents. Now the High Court is saying that these are two very, very different matter. They are very materially different matter. They are not actually in conflict or they are overlapping matters. Now they are saying that a prospective licensee, in this case Micromax and Intex, can approach the controller of patents to actually ask for a grant of compulsory license in certain cases. So they are saying that it will be open for the licensee to approach the controller of patents for procuring the license of the patent. Now, just because they have approached the controller of patents for compulsory licensing, it will not be inconsistent with the CCI passing an order saying that it is an abuse of dominant position. So they are saying that parallelly both the proceedings may continue. Just because somebody has filed for compulsory patent under section 84 of the Patents Act, that is not inconsistent with the CCI passing an order with regard to section 27 of the Competition Act. Now again, to draw the point that both the legislation can be read harmoniously, the court further looked into section 21 and 21A of the Competition Act. So section 21 and 21A of the Competition Act, if you refer to the Bare Act, says provides a mechanism by which if the Competition Commission of India feels that there are certain overlapping matter and they need the view of another statutory authority under section 21A, they can refer the matter to the other regulator. Under section 21, if any other sectoral regulators feel that the issue raised has to be decided by the CCI, they can actually refer the matter to the CCI. So the High Court says with regard to this issue that the Competition Act is meant to be implemented along with any other laws such as the patent law, rather than actually leading to irreconcilable differences, or implied repeal. So they're saying there's no question of implied repeal. These provisions makes it clear that the intention of the legislatures has been to read Competition Act and other laws such as patent law harmoniously. Now, the court finally held that looking into all these provisions, the two legislation can indeed be read in a harmonious fashion, and on a deeper reading of the question, it becomes apparent that there is no conflict between the two pieces of legislation. There has been several allegations made by Ericsson against the two companies Micromax and Intex. The issue number 3 is whether these allegations which are made by Ericsson, can it be constituted as an abuse of dominant position, is the issue that the court is looking into. Now the court says that in some cases, if the standard essential patent holder seeks injunctive reliefs, they may amount to abuse of dominant position. And especially because if there are evidences to show that this kind of a threat of injunctive relief is exercising undue pressure on the prospective licensee and putting him in a disadvantageous bargaining position vis-a-vis the standard essential patent holder, and because of the risk of suffering injunction if the prospective licensee succumbs to the pressure and on certain disadvantageous condition agree to the licensing agreement with the standard essential patent holder, then definitely it can be constituted to be an abuse of dominant position. Now, if you look into the third point, you see that the court is saying that the position of a SEP proprietor and the proprietor of a normal patent are very different. So in the former case, that is in the case of a proprietor of a standard essential patent, there is no non-infringing patent available to them. Because the standard essential patent has been declared to be standard with regard to a particular industry. So everybody who is in that particular industry has to mandatorily procure that particular license. So there is no substitute available to the enterprise in such condition. Whereas in case of a normal patent, in the case of a normal patent, the dealer or the manufacturer may have other non-infringing options. So this market condition actually makes the position of the standard essential patent holder much stronger than compared to a normal patent holder. If you look into the next slide, Ericsson also threatened Microsoft with complaints to the SEBI the moment Microsoft was planning to actually float a public offer of its shares. So the moment Microsoft was trying to take a decision, so Ericsson said that they will approach SEBI, another sectoral regulator. So the court said that this is nothing. This is a good enough evidences of the fact that Micromax was being influenced to conclude a licensing agreement as per Ericsson's wishes. So this was actually an abuse of dominant position. Now, the court said that in this particular case, because they are just looking into the jurisdictional issue, they are not looking into the abuse of Ericsson's dominant position as such, but whether CCI actually has the jurisdiction to deal with this case or not. So they're saying that we don't have to necessarily examine all the matters right now, but sufficient to say, we can say that in certain cases, this kind of a threat of a standard essential patent holder who is found to be in a dominant position, it can be constituted to be an abuse of dominant position. So these kind of unnecessary threats that will threat it to another sectoral regulator like SEBI, or that we will file injunctive suits against you. So these at times can be considered to be an abuse of dominant position, is what the court has said in this particular issue. Now coming back to another issue, can Micromax Intex maintain a complaint for abuse of dominant position since they had contested Ericsson's claim for infringement? I told you when I was taking the online lecture that there were two pending petitions. So one is Ericsson filed for infringement of patent against Microsoft and Intex. In that particular case, Micromax and Intex has actually said that, has defended, saying that actually Ericsson does not have a patent in those technologies, and also they have filed for revocation of patent in another suit. On the other hand, before the CCI, they have complained that there is an abuse of dominant position. Now, Ericsson has said that on one hand, in one suit, they are saying that Ericsson is not the actual proprietor of the patent, and so when they're taking that claim in one suit, in the next suit that before the CCI, they cannot say that Ericsson is abusing the dominant position, because when they're saying that Ericsson is abusing their dominant position, they're acknowledging the fact that Ericsson has a patent over that technology. So Ericsson is basically saying that you cannot have two different positions in two different suits. Now let us look into what the court has to say. Now the court basically look into point number 2. The court refers to section 141D of the Patent Act and says that in that particular provision of the Patent Act, it is mentioned that just because a person has entered into a licensing agreement for a patent, just because company and individual enterprise has become a licensee of a patent, it does not mean that they have no right to challenge the validity of the patent, which means that even if you are a licensee of a patent, you can even after that file against the validity of the patent in hand. So section 141D makes it unlawful to actually insert any provision in the licensing agreement that in future you will never challenge the validity of a patent. So the court makes it very clear that this provision itself make it clear that you can also be a licensee as well as you can file for the validity of the, you can challenge the validity of the patent. So they are saying that in this particular case, although Micromax and Intex has said that Ericsson has abused their dominant position, in another suit they can definitely contest the very validity of the patent, saying that Ericsson is not the rightful owner of that particular technology, or Ericsson is not the patent owner of that particular technology. So they're saying that these two are not in conflict with each other and they're two very different things and it can both exist simultaneously. So the next important issue is whether the orders that were passed by the CCI was without jurisdiction or not, because that is the main claim which is made by Ericsson, that CCI does not have the jurisdiction to basically decide this, did not have the jurisdiction to ask the DG to examine the matter, because this is a matter pertaining to the Patent Act and not the Competition Act. Now the court, while giving decision as to this issue, basically said that they cannot give a very clear-cut decision whether it is an abuse of dominance or not, because there has been evidences to show that Ericsson has actually made efforts to have a negotiated settlement with Micromax and Intex with regard to patent licensing agreement, and they basically said that. And even after knowing that they were using the patent of Ericsson without their permission, even after or without procuring the license or without going to the controller of patents for a compulsory licensing, even after that, Ericsson has tried to arrive at a negotiated settlement with them. So it is difficult to form an opinion that Ericsson's conduct we can conclusively say that it's an abuse of dominant position. Also, the second point, there have been very severe allegations made by Microsoft and Intex against Ericsson, and any reasonable person, by going through the complaints, would see that yes, prima facie there are matters that might constitute abuse of dominant position. There has been this particular issue raised in many cases that we have discussed much earlier also in the beginning of your semester. And if you remember the decisions, there has been a Supreme Court decision also on this particular question, where whether the CCI has the jurisdiction to deal with the matter or not, when they ask the DG to investigate the matter, pass the order to the DG to investigate the matter. So in all those decisions, including the Supreme Court decision, the courts have just said one thing, that okay, you might not give a very detailed order asking the DG to investigate the matter, but there has to be enough materials in front of you to actually come to a decision that the DG needs to examine the matter, which means that if there is no material at all, then definitely the CCI is wrong in asking the DG to investigate the matter. But even if they are not giving a detailed order, but if there are sufficient materials to show that yes, this is a matter that needs to be investigated, then it's a good enough decision, and in that particular case, you cannot question the jurisdiction of the CCI while giving its order. Now, in this particular case, the High Court is saying that the CCI was correct in asking the DG to investigate the matter, because there were sufficient materials which indicated that there might be an abuse of dominant position by Ericsson, and hence the CCI definitely had the jurisdiction to pass the order asking the DG to investigate the matter. So this is the entire decision of the High Court in this particular Ericsson versus the CCI case.